Naked Lunch is one of those controversial texts that I continue to come back to because of the way that it interfaces with the culture of its time. To me, William Burroughs as well as Naked Lunch are emblematic of the historical moment from which they spring. They act as radical extremes of the type of tendencies latent in society that were begging to be brought forth. The more overt respect for homosexuality, for example, was begging to be had. And we can see this playing out in the court case surrounding the supposed obscenity of Naked Lunch, which from 1959, after its publication, all the way until 1966, when it was finally deemed not obscene by the Massachusetts Supreme Court, this dealt with the nature of Naked Lunch. Was it pornography? Was it obscenity? Was it something else? And did the government have a right to step in and prohibit it from being sold? In Katie Arthur's essay, Arousing, Disgust, Visceral Configurations of the Queer, Obscene, and Pornographic in the Reception and Trial of William S. Burroughs' Naked Lunch, she tracks the legal progress of Naked Lunch and the various arguments that were being made by the prosecution and defense for whether or not Naked Lunch was obscene. And in particular, Arthur wants to keep a close eye on the way the bodily in the visceral is evoked both as a defense and an attack against Naked Lunch. Indeed, to talk of something as obscene means that we need to, for example, consider whether or not it appeals to prurient interest. As the United States Supreme Court has stated in Roth v. United States, one of the landmark cases regarding obscenity law, the court held that the test to determine obscenity was, quote, whether to the average person applying contemporary community standards, the dominant theme of the material taken as a whole appeals to prurient interest, prurient meaning sexual in nature. So in order to describe something as being obscene and therefore outlaw it, it requires being able to recognize its sexual potential, the ability to excite and appeal to prurient interest, which creates a very unique paradox that Arthur wants to point out. It seems to me that Naked Lunch is a properly queer work, at a time when this term was in the liminal zone between its two meanings, the first being strange or odd, as in, well, that's queer, or the second, that being unorthodox sexual behavior or identity, as in, I'm queer. It cannot be considered pornographic, in my opinion, because Naked Lunch is undoubtedly concerned primarily with disgust, horror, and confusion, not sexual arousal. Yet, it can't necessarily be considered obscene either, since firstly, it contains a wealth of social commentary and stylistic inventiveness that indicates artistic merit. And secondly, the legal notion of obscenity requires a rationalistic, detached aesthetic eye which can no longer be adopted if one is to effectively categorize Naked Lunch. This created a real legal problem when it came to classifying Naked Lunch, because the question was, is the disgust some sort of moralizing statement in which the point is to become disgusted such that we want to change and go away from the actions depicted in Naked Lunch? Or is the disgust supposed to appeal to some kind of latent animalistic interest? Is it supposed to arouse us? Both of these sides are going to be used by the defense and the prosecution respectfully, and as such, the quality of disgust is very central to understanding Naked Lunch. Expounding upon this point, Arthur states, as aesthetic judgments of moral standing increasingly relied on evidence of bodily response, the stomach churning of disgust allows depictions of queerness, the bodies and forms of embodiment deemed queer, to pass the censor. With non-normative sexual desire deemed patently unerotic, courtrooms grappled with the special competence needed to make sense of, quote, deviant interest, as obscenity law demanded evidence of the sexually arousing. The assertion that Naked Lunch only solicited the limited visceral response of disgust freed it from the courtroom, but simultaneously denied the erotic potential of the sexuality it depicted. And this is one of the central problems regarding the legal state of Naked Lunch is it seems that it's not primarily concerned with being erotic, but more so with being deviant, radical, extreme, visceral, bodily, and disgusting. As such, one is torn between whether or not there is a moralizing message, as I just said, behind that, such that we're supposed to be disgusted by this type of sexuality in and of itself, or whether or not this is merely some sort of aesthetic tool that is not necessarily making a moralizing judgment. Arthur states, "The attention to bodies exposes how subjective visceral response is deployed in designations of obscenity, even as obscenity law lays claim to an aesthetic, objective mode of seeing. By examining how the meaning of naked lunch circulates through descriptions of visceral response, I illuminate how bodies are solicited and put to work for claims to moral meaning and moral standing. The reliance on the visceral by courts and critics illustrates how meaning is made on and through bodies. The case reveals how courtrooms increasingly struggle to prosecute works as the definition of obscenity narrowed to material deliberately intended to sexually arouse. Visceral response becomes indicative of obscenity, and naked lunch avoids censorship on the grounds of being emetic rather than erotic." And I think this is very interesting. This neutral, aesthetic, objective mode of seeing is the kind of thing used in legal litigation in order to determine the status of naked lunch. But we're talking about something called obscenity, which necessarily invokes, as the Roth test stated, community standards. It requires people invoking the way it makes them feel. As such, the court is in a very particular situation in which bodies, including those of witnesses, experts, and judges, are put to work in order to give some moral precedent to a legal ruling. As such, there is a very close relationship here, where it's mentioned that in the 1933 obscenity trial for James Joyce's Ulysses, the New York District Court cited that the meaning of the word of obscene is tending to stir the sex impulses or to lead to sexually impure and lustful thoughts. Now, considering that this is 30 years before the trial, a lot has changed, but nevertheless, even back when Ulysses was being tried, we can see that the tendency to stir the sex impulses or lead to sexually impure and lustful thoughts requires in some sense that one can acknowledge that potential, maybe even be excited or afraid of that potential. Think about the way in the master-slave dialectic, Hegel talks about the fact that in order to recognize the other as some sort of independent entity, there's a very paradoxical situation in which one must recognize the other through its sameness to oneself. There must be some sort of affinity such that, for example, we are both persons or moral agents or valuable or humans or autonomous or whatever. And we can identify these because we resonate with them in some sense. So thus there's a strange closeness that the legal team has to get to the obscene material itself. Now there's a very interesting case in which Judge Stewart on this case famously mentioned that he couldn't really define what hardcore pornography meant. Because one of the questions was, okay, it's clear that the law should restrict hardcore pornography. But if something has the potential to sexually arouse, but it's not primarily concerned with it, then it's okay. What we're concerned with, so the court said, is whether or not it was completely overwhelmed with that as its primary impulse. And Judge Stewart famously continued to say that I know it when I see it with regards to obscenity. Now, I think this is a very interesting quote, and Arthur does too, stating that Florence Doré argues that I know it when I see it is not an idiosyncratic assertion of authority, but rather a defining aspect of obscenity in American law. Justice Stewart's comment attempts to position the obscene as an identifiable aesthetic mode, hardcore pornography. Yet it also imparts the futility of defining the obscene. One could never succeed in intelligibly doing so. Stewart's comment concedes the impossibility of a rigorous framework for identifying obscenity, and entangles the obscene with the visceral, leaves us with the seeing eye of the body, even as it attempts to use that image of the eye as a means to establish objective aesthetic taste distance from physical feeling. And it's very interesting how the body is evoked here with this visual imagery of I know it when I see it. Because we assume that seeing is something detached. It's not something bodily in the same way that, for example, tasting or touching is, or even smelling is. There's some distance that we can have by seeing. We can see it from a distance in which we have an objective appraisal of the qualities at hand, not marred by, for example, the more subjective qualities of taste. But in fact, I know it when I see it shows the extent to which the body has to be invoked and has to participate in the obscene material to a certain extent. Arthur continues, Stewart's comment encapsulates the strange paradox of viewing the supposedly unwatchable that underpins the policing of the obscene. To know the obscene through seeing posits that to properly designate the object as unwatchable, it must be watched. It is an inherently voyeuristic case of looking, reading, and surveillance, one that is reflected in the strangely sordid history of the policing of both obscenity and queerness. Seeing, as highlighted by Justice Stewart, is a mode of identification, detection, and regulation. I'm hearkening back to Foucault when I hear that. But the use of seeing in this case also carries an implicit absence of feeling or emotion, an attempt to shore up the possibility of rational and objective acts of interpretation. The policeman engaging in queer sex acts as part of his investigation is protected by the implied duty that counters allegations of pleasure-seeking. Similarly, the censor is shielded by their positioning as watchman, both warden and custodian of the imagined public that forms the reason for their role. The history of censorship has involved a judicial seeing eye, providing a rational and objective account for a visceral, feeling public. The rational side of the censor is positioned as necessary to judge and delineate the obscene due to its ability to detect, but never participate in, the material's encouragement of highly unseemly and potentially socially unsettling visceral response. By framing judgment through the act of seeing, the censor, judge, or policeman averts insinuations of their submission to the material's intended bodily response, with claims to an aesthetic judgment. I know it when I see it declares that it is a matter of the controlled and rational seeing of aesthetic taste rather than the impulsive and automatic feeling of physical response. And it seems clear to me, and Arthur is very skillfully pointing this out, is that this binarism between a abstract rational aesthetic taste and an embodied sort of infatuation with something seems to be an arbitrary binary. Our body is always implicated in the reading process to some extent. It's just that typically this is not brought to the fore. And it seems to me that this is one of the key things that Burroughs is trying to do in his readers, is to bring out and accentuate the role of the body in reading. Arthur continues, Stewart's comments revealed that the aesthetic category of obscenity is judged, prosecuted, and criminalized through watching. It is known when it is seen. This mode of aesthetic interference and inference is enacted through a cultural privileging of sight and consequent negation, circumvention, and diminishing of other senses. But when does seeing become feeling? To know the obscene text is to become fearfully aroused, nauseously disgusted, or out of sync with punchlines. What then does it mean to return to other bodily sites to read texts? What does it mean to read with sweaty palms, bilious stomachs, and erect penises? And I think that's very interesting that maybe Burroughs is asking us to be aroused not in a sexual manner per se, but in an affective and bodily manner, in a multiplicitous manner in which the reader can really make the text one's own, such that one cannot step back and supposedly give an objective appraisal of what Naked Lunch even is. The title of this lecture, for example, gives a couple different options, and I think queer is perhaps the only good descriptor, precisely because it's not very descript. It's very ambiguous. In fact, it's almost a negative statement that relative to some established social body of practices, it instead stands beyond. As Arthur states, the trial and reception of Naked Lunch reveal how the queer, obscene, and pornographic were configured through imagined visceral responses in mid-century America. These imagined visceral responses being these normative community standards against which queerness acts. Burroughs' book illuminates how courtrooms and critics become embroiled in the sensational even as obscenity law attempted to distance itself from the feeling bodies it wanted to police. And I think that's very interesting when you look at, for example, some of the testimonials and witnesses and whatnot during the court case. They were very much focused on calling it, for example, literary sewage, or giving all these very visceral responses to the text, which seems to me to accentuate exactly Burroughs' point with writing the text. Arthur mentions how a reviewer states that instead of embodying life-affirming lust like works by Henry Miller, Naked Lunch is on the side of death, filled with images of pain, illness, cruelty, and corruption rather than sex. The reviewer finds Burroughs' depiction of sex unerotic, comparing Naked Lunch to the writings of Sade, but without the saving wit and irony. Yet to overlook the sexual components in Burroughs and Sade's writing is to miss an important aspect of their work. As writers that straddle the arousing, humorous, and disgusting, Sade and Burroughs do not affirm the categorization of pornography as separate to other aesthetic modes, but to complicate the cultural distinction of the aesthetic object proper and the erotic or explicitly sexual. And I think this is very interesting because there's always a potential that something can be read as sexual. And one of the dominant interests of the court here was trying to find some sort of consensus for when something was deemed arousing. And I think it's very interesting because this kind of makes Naked Lunch in between two categories, that being pornography and obscenity. Now, of course, pornography is primarily concerned with lustful infatuation and arousal. It's sensationalized, it's fantasy, it's almost romanticized, whereas obscenity is just, so unorthodox of sexual behavior that it can't be seen as arousing. And Naked Lunch is somewhere in the middle because it's not classical obscenity insofar as it's just homosexual sex, for example. It's much more grotesque than that, such that it doesn't even seem whether or not we can establish that it appeals to prurient interest. Arthur states, denying a pornographic mode of address, that is the sense of a structural or authorial intention to sexually arouse, was key to the cultural wrestling of the book into a category of the queer, unerotic, and unacceptable. It was also, however, central to the defense of the work at the obscenity trial. And I think this is very interesting, where Naked Lunch comes to occupy a mezzo category that is neither sexually arousing nor obscene, despite the presence of extreme sexual matter. And what else could we call this other than queer? And this is the way that the defense was actually able to protect Naked Lunch in the obscenity trial, is that the queerness of the text and the uneroticism of the text made it unacceptable, such that according to these common community standards, it didn't even seem like it appealed to any arousing interest, and as such, it wasn't deemed obscene. As such, there's an implicit value judgment here, which we'll get into more later, which goes along with the presence of homosexual content in the book. Arthur very expertly states, while Justice Stewart claimed that the obscene is known when it is seen, his epistemological reliance on rational, unfeeling sight is displaced by the feeling body in cultural commentary regarding Naked Lunch. Knowing is articulated through the terms of the visceral, not the rational. When a negative review of Naked Lunch caused an ongoing flurry of letters in the UK Times Literary Supplement in 1964, one person recalls that they, quote, choked down Naked Lunch in spite of almost intolerable nausea. The reader's embodied response dictates their separation of the literary form that Burroughs references, poetry, tragedy, the treatment of sin and conscience, from the, quote, filth he has created. To read viscerally, to be choked or roused to nauseous revulsion by a book, renders it outside good aesthetic taste. Evoking such bodily responses renders the book filth, appealing to base bodily reactions and foregoing the non-bodily treatment of morality found in good or, quote, high literature. Of course, such distinctions are largely arbitrary, rooted not in an objective aesthetic delineation, but instead those determinations of a proper aesthetic object in a particular time and place. This is very similar to me to Deleuze talking about sense, where, for example, a word or statement or phrase has sense, and sense is based partly on, for example, common sense, what something is supposed to indicate, what it is proper to represent. As such, there's a value judgment or a moral statement that one ought to use certain words for certain purposes. In the same way, Naked Lunch kind of gets around the traditional literary notion because it doesn't appeal to morality in the classical sense. It doesn't appeal to aesthetics in the classical sense because it's not trying to be beautiful, and yet it is still aesthetic. The liminal and therefore radical state of Naked Lunch is aptly put when Arthur mentions a review in the Washington, D.C. News, in which the reviewer states, actually, Naked Lunch is mostly about excrement. It is not a work for simple seekers after pornography, and I suspect even the avant-garde crowd will be left behind on this one. The reviewer distinguishes Naked Lunch from both the simple erotic thrust of pornography and the beguiling high art of the avant-garde. Naked Lunch is not important then as pornography or high art, but rather because it undermines the distinction between the two. Now, this liminal state is very tricky for the legal situation because, for example, the accusations of disgust in Burroughs' work were given a moral cadence. Rather than indicating the work's dabbling in the lurid and immoral, the rousing of disgust is positioned by the defense as an attempt to arouse, quote, moral consciousness in the reader. The cognizance caused by embodied response makes disgust a moral strategy. Now, I think that this is a dubious moralization of a markedly amoral work. It seems to me that they're trying to make Naked Lunch a much more moral text than it actually is, some sort of reformist text. I think that that would be to co-opt it into a stable political order, which Burroughs is not willing to see, in fact, as the primary order. Burroughs recognizes the state and the government as a secondary construction created hodgepodge-like out of a cut-up, and that it is our job as artists and theorists and thinkers not to become moralistic, but rather to become enamored in the bodily. And yet, the idea that this arouses moral consciousness, that it's supposed to be some kind of satire with the goal, like, I don't know, Jonathan Swift or something, that it's supposed to indicate some kind of change in the moral fabric, is potentially an advantageous way to frame it legally. Visceral feelings, Arthur states, of any kind, indicate an obscene book, lewdly appealing to its reader's lowly bodily instincts. The conflation of the obscene and pornographic is rooted in the visceral stirrings of the embodied reader and perceptions of disorderly bodies. Hans Mayes, in 2013, has argued that the division between aesthetic and sensual pleasure in modern aesthetic theory dates back to Immanuel Kant's Critique of Judgment from 1790. Kant thought that a judgment of beauty was based on a, quote, disinterested pleasure, a pleasure that does not depend on or generate a desire for the object. The titillation of pornography, on the other hand, provokes an interested pleasure or a judgment of the agreeable. Pornography is defined by its rousing of bodies or evocation of bodily arousal. And this dualism, of course, is a classic rationalist assumption that you can have some disinterested appraisal of the beautiful as such that isn't enamored with the body. It seems to me that this is one of the dynamisms that Burroughs is the most critical of. Arthur writes, "The disintegration of bodies, Burroughs' visceral aesthetic, carries the fearful potential of summoning the disorderly bodies it depicts. Burroughs' deep engagement with bodies, deemed failed or failing in Naked Lunch, that being the queer, addicted, sick, and criminal, explicitly concerns the prosecution. By analyzing how the defense redeploy the Burroughsian body in service of a moral significance palatable to the courts, the trial reveals how anxieties around bodily propriety are reflected in the courtroom. Despite the law's emphasis on unfeeling judicial sight, the court transcript for Naked Lunch illuminates how bodies are put to work as evidence of a book's moral meaning, and as a consequence, its moral standing. Furthermore, Burroughs' depictions of non-normative sexual acts were held as colloquially obscene in cultural criticism, disgusting, indecent, and disorderly. Yet for the court to find Burroughs' book legally obscene, the colloquial sense of obscenity as disgust had to be navigated into evidence of the book's prurient or pornographic appeal. Naked Lunch treads the line between the arousing and disgusting, similar to Joyce's Ulysses, and that both books cast anxiety about their prurient appeal in deviant desires. The trial of Naked Lunch was an attempt to regulate sex and desire, to determine the representation of certain forms of sexual practice as criminal and obscene. And I think it's really important that we consider the implications of deeming something legally obscene, because it does make it criminal to express and to represent that point of view. As such, there's something very anti-libertarian, very anti-democratic in a sense about this. Because whether or not something arouses particular feelings, even someone like St. Augustine is aware that the law is not meant to outlaw all possible crimes, just that which prohibits the Christian life from being lived. That it's up to the individual to navigate the particulars, and that law, because it is in general, and Aquinas agrees with this, it therefore cannot arbitrate every particular situation. As such, we have this colloquial generality which is hard to nail down in the legal sense, because, in a sense, Burroughs' work can be seen as revolutionary, possibly demanding the oppressed bodies to stand up, to have themselves heard. And as a result, it's very difficult to counter this in another way other than to weaponize different legalized bodies, such as those of the acceptable community, as an opposition. Arthur mentions the way that the defense exploited the assertion that the book's primary intention is the evocation of disgust by establishing and recasting its depictions of homosexuality within a moral framework that was tenable for the court. And I think, and I'll just read this, I think it's a terribly problematic interpretation of Burroughs' aesthetic project, but perhaps the only tenable one for the court at this moment in time. De Grazia, a member of the defense, draws a choice selection of quotes from the witness testimonies for the brief for the appeal. De Grazia exacts Allen Ginsberg's assertion that the homosexuality in the book portrayed the author's disturbance and fear of it, and ultimately his freeing himself of it, defeating it, as well as Dr. Thomas E. Jackson's claim that the homosexual episodes conveyed a misuse of the penis similar to the misuse of the hypodermic needle by drug addicts. Now, I think this notion that Burroughs' goal was to rid himself of his homosexuality, to free himself of it and defeat it, is a terribly problematic assumption that I think was perhaps only legally beneficial. But there's, and Arthur shows this time and time again, there is a deliberate avoidance of any notion of the book's erotic potential, because this would simply be too much for the courts. As such, I think it's very interesting to consider the way that the queer is defended here, and it really shows the development of queerness from the 60s to now. Because queerness was defended, in a sense, precisely by putting itself in a box that lied beyond legal distinctions, precisely because it was so unacceptable it could not be seen as having interest which would warrant it being deemed obscene or pornographic. As such, I think this is a really interesting way of thinking about the evolution of queerness and the role of Naked Lunch in this fight. That being said, that's it for this video. Consider checking out any of my others I've done on postmodernism, German idealism, gender theory, post-colonial studies, and other literature. You can become a channel member for $5 a month and gain access to, among other things, a private philosophy Zoom, which you can tailor to your needs. I also have super thanks if you'd just like to donate to the channel, because books are not cheap, and as a poor college student, I'd appreciate anything you have to give, but no pressure. That's it for this lecture, and I'll see you in another one.